objections. And
If
then
you have a relevancy objection and you can see where you are in the case, the questions are to continue in that vein, it's good to ask, you know, Your Honor, we're making a continuous objection to the relevancy, so you don't have to keep interrupting all the time. It's annoying to the bench officer. So, you know, use that in the right way and the right time.
or when you feel that the county is really leading the questions, and every question that they're asking, because the judge is giving, or the bench officer is giving them wide latitude to ask leading questions, again, you would make that a continual objection to this form of questioning. And as Bob said, you wouldn't have to keep objecting. But you need to object, because if it's leading, and again, another reason to object is to preserve the record. Any questions on that part of it? No? Okay. And then on page 9, I outlined some objections because of privilege. We don't really use privileges that much here. And but one of the things I noticed in the current California Evidence Code for 2016 is that they have another privilege here. You may not use it in your courtroom, but if you're in if you're in 417 and you're dealing with this particular situation, there is a human trafficking caseworker victim privilege, which I have noted. So you never know that may come up too. There is a privilege. And what else? And as some of us should know, one of the privileges that is not that we cannot use here, or that is not used here, is the marital privilege. So we have a lot of DV situations, and you would think, oh well, how is the husband going to testify against the wife, or vice versa? Well, to be able to testify, not testify, or against another spouse is not applicable in dependency in juvenile court proceedings. So again, you have your common objections, which is argumentative, asked and answered, assumes facts that's not in evidence. You have the best evidence rule, and you have information on that and how to use the best evidence there. You have another objection of direct or cross, which is beyond the scope of cross. Don't let the county or another party ask questions that wasn't on direct, because you open the door. And once you open the door, everybody can then start asking those questions that was beyond the scope of your direct.
Ms. Cunningham?
Yes.
You mentioned earlier about objecting to either the Children's Counsel or the trial counsel's misrepresentation of facts during their closing. I've run into that situation. Do you do the objection while they're making their closing argument, or do you wait until they finish their closing argument?
Sometimes it's a matter of style, and it's again, your bench officer. How do they look when you're objecting in the middle? To me, again, it all depends on what they're saying. If I think that they're really being mean, I would object. Again, that's style. However, maybe the better practice would be to address that in your closing argument. I object to county counsel saying this. I object to minors attorney saying this, or you can save that for your closing arguments. So it kind of depends. The other thing I wanted to mention is that when you are objecting, and you're objecting to something that's non-responsive and they've said something harmful, after you have made the objection that is non-responsive, you have to go another step further and move to strike the answer that they have said. As well as if they've answered a question and it was yes or no, and they gave a whole dissertation about it, you can move to strike everything that was after the answer that was after the answer to your question, whether it was yes or no. Is any questions on that one? Did you want to add something on that one?
No, that's really important, though. That's overlooked a lot. The motion to strike.
Because if there's not, and again, you're preserving the record. If there's no motion to strike, then it stands. The bad information that you object to, that's inadmissible.
Question over here.
So if, Sherri?
Yeah.
Okay, so say you move to strike because they said some harmful comments, but then can the county then cross on that or because they've opened the door?
I'm sorry, what?
So my question is, your client says something non-responsive, but it ends up hurting you and they've opened the door to some issue you didn't want covered. And then you move to strike and then county council goes and they question on that exact issue. Can they do that and say they've opened the door now?
Well, you can't say you've opened the door because you've moved to strike and it's stricken, so it's not part of the record.
Okay.
However, the department could come back and ask another question in their cross-examination. Again, that kind of would be like the loop question, where you don't want your client saying too many things. And so another thing that I didn't mention, and part of preparing your client, your witnesses, is preparing them for cross-examination, is to prepare them for direct examination. What are you going to ask them? You know, if you can go over their testimony, because you may be in a department where the county likes to call, your clients. You have to prepare them. You may not be preparing them to testify for you or on their behalf, but you would be preparing them to go, to be able to stand up against the against the department. And again, you would kick in your objections to protect your witness, because one of the reasons for objections is to protect your witness. Do you have anything to add to that, Bob?
Not so far.
Okay, is there any other questions?
I have a question. Sure.
Yes.
The psychotherapist privilege, if that is in the social work report, how do we, what's the proper vehicle to object to statements by the psychotherapist or attached? Can you assert the privilege? Would you do it orally when it's
You would,
conveyed?
if it's in the social worker's report.
Yes.
And what stage are you at?
Trial. or
You're at trial, you're at
particular
pre-dispo. You have the vehicle of that beautiful thing called the 355 objection, right? You file that motion, and then you object to that. And when you object to that, you're objecting for all of the reasons that you feel is objectionable. It's privileged, it's not irrelevant, it's, but then again, you know that even if you object to it, what the department has to make that person available, or if not, the judge cannot use that as the sole basis for making this decision. But I believe that you will start with your 355 motion, objecting to any evidence that you think is harmful.
What if it's post-dispo at a review hearing?
And if it's about the psychotherapy, has your client signed the release for this information? Have they waived the information? You were looking at. And if they haven't waived, if they haven't signed the releases that allows the social worker to follow up on the case plan, which they're supposed to be doing, then you attack it on the same manner. But post-dispo, you assume that the judge has told you to sign our releases so we can get updated information.
Right, but releases can be limited to what information is permitted to be disclosed.
So if it's not something that you agreed to, then you have the same objections. It's privilege. I didn't sign for it. It's a limited admissibility. You make your objections. Was that your question? Did I answer your question, John?
Yes.
Okay, great.
You know, I'm not sure if any of you do this, and maybe a lot of you do, maybe you were taught this in law school. But I always thought it was good, after I reviewed a case, looked at all the reports, as a lawyer, not as a hearing officer, to look at everything and evaluate my case and write the closing argument first. Write your closing argument. That kind of tells you then where you need to go with your direct and cross-examination. You may have to fill in the blanks as you go along, but it gives you a good sense for how to conduct your direct examination. It gives you a path, it gives you a roadmap where you want to go with your case by writing your closing first. I don't know if any of you do that. I remember when I did some civil cases before I would do that, and it would make a big difference in the way I would prepare the case. So just some food for thought.
And one other tip on the protocol for objecting. You make an objection, or the department makes an objection, and then they want to argue. You make an objection, and you say it's leading. Then county council is saying, oh, it's not leading, it's this and this. What I'm trying to say is don't cross-argue. You don't argue with county council while you're making the proper objection or where you're going with it. Argue it to your bench officer. Don't cross-argue. And that's pretty much with anything, because the person who makes the decision about which you have the dispute on is the bench officer. It's not county council or minus council conceding to your point, and if it is, it's good. But most of the time, who's resolving the dispute you're having is your bench officer. Anything else about protocol? Objection?
Some of our seasoned lawyers, do you want to add things that maybe you can put in here? I know Adam's very seasoned, other people we have in here that may want to add some things into what we're talking about here. Rachel?
Well, Jasmine had a question that I thought about your Fifth Amendment right, even if you're not facing criminal prosecution, and I think you do still have that right under the Constitution, as discussed by Mark A. So I think wanted to offer that, even if you're not being charged with a crime, because you could potentially be charged with a crime based on what you say.
And I think that's very effective to use, especially if you have a county council whose idea of resolving or punishing you or your client, if you're gonna go to trial, is by putting your client on the stand and beating them up. The other thing is, I think we should always endeavor to be professional and not allow things to break down into personal assaults. And it's your bench officer's job to control their courtroom and to admonish counsel if they've gone too far. You absolutely should not say something to counsel across the table, but you absolutely should bring it up to the judge each and every time. And as to the minors' counsel testifying in their closing arguments, excuse my language, but I'm a bitch. And so if you're gonna do that, then I'm gonna object. I'm every time you open your mouth in closing. And your bench officers say, well, counsel, you know, it's closing argument. Yeah, it's closing argument, but she's testifying. That's something wholly different. I talked to my client told me they were crying, and I mean, you've all been there.
And I think it's more effective to not save it when you're doing your argument, but interrupt it and object immediately as soon as they say it, because first of all, it stops them, and it draws the attention to the judge if they're half asleep that maybe they shouldn't be saying that. You assume that they understand they should, but if you just let it come in, although closing argument is not, you know, it's not evidence, they take it all in, especially if you have a really difficult case. And when they start talking like that, sometimes we're falling asleep ourselves, but you've got to really be aware what the minors attorney is saying, because the judges, commissioners, whatever, listen really heavy to what the minors are saying. If they're starting to put on a case that you've never heard about, then it's wrong, and they have to be called about. And sometimes I'll even go up to them afterwards and say, you know, look, you're really not supposed to do it. And if you continue, I'm going to interrupt you every time, which makes it, you know, difficult for everybody. But haven't you learned? Because sometimes, especially the newer ones, they sit there and they have, oh my God, my client said this, and you're sitting there and listening to things that you've never heard. They haven't put them on, and I think they need to know. And the other question, one of the things you were talking about, records that will come in before, if you have like mental health and things like that. I can't remember the code section, but especially if it's before adjudication, the department, and sometimes they will go and get medical records or evaluations before they get any waiver. If they don't get a waiver, they don't have to. Another civil code, probably someone would know the civil code, everybody has to be noticed, especially your client. And there's a whole form, I mean, there's motions, people probably have it in their firms. You've got to file those to make sure they stay out, and there's a certain procedure, and if you don't say anything, and you know, it can really be damaging to your client. It's under a civil code about notifying the people that these records are, it's a consumer type of report. I don't, you would know.
Can I just address that issue? If it's pre-dispo and they're trying to introduce medical or psychiatric records, the privilege is there. They cannot introduce it. And that is a motion in limine, or it's an objection as to privilege. It is a complete bar, and they cannot get those records in. The problem is, post-dispo, once the court has jurisdiction of the child and has made the child the defendant, you will hear the court order the clients to sign the releases. Our clients don't have to do it, but the problem is, if they don't, they probably will never get reunification, or you will see county council at all of our 2-1E, 2-1F hearings pounding on the clients because they're not providing the court with the information the court needs to make the relevant determination as to risk, because the client is blocking any of the therapists. And you're gonna, you'll see that. But before the child is made a dependent for jurisdictional purposes, county council cannot be entering our clients' medical records as to minors counsel. The child holds that privilege. If we try to introduce psychiatric or therapeutic records of the child, there's case law on point, I think the minors counsel will be able to prevent us introducing the psychological records of the kid.
I totally disagree with Marlene. That's what we do.
I think there's case law on that as far as minors counsel.
No, I'm not talking about the kids, I'm talking about us. If the mental health issue is not something that has to do with your case or that hasn't been sustained, they don't just get your client's medical records carte blanche, and you don't have to sign that part of the case plan. You can amend it, saying if mental health has something to do with what was sustained, you can, I think, what does it say, any and all, and it's just very, very broad. You can narrow it, okay? You can write in there specific language that they can get, I don't know, maybe they can get the conjoint therapy between the child and the mother's notes, something like that. But you don't want to allow them to go all the way back to when your client was a kid and almost committed suicide. I mean, because that's what it is. They will get everything, and trust me, they will use it against them.
But the problem is, because I hear time and time again, if it's a mental health issue, things that are going on at that point, and there's nothing, you've kept other things out. The judge will say, I'm asking you, I'm ordering you to sign, but I can't force you, and if you don't want to, then we come back with the 2-1E, 2-1F, 2-2, and I don't feel comfortable that you've addressed the issues because, we want to know completely that the child's going to be safe, and they haven't signed things. It becomes extremely difficult. So I think if you can dare it, that's
what I'm saying, Rachel.
That's what
They don't
she's
have
saying.
to. I said
Yeah.
post-dispo, clients do not have to sign the waiver. The consequence is if they choose not to sign the waiver, and by the way, if they're doing conjoint counseling, they've waived the privilege, okay? Because both parties hold the privilege, which means minors counsel on behalf of the child can now get into all that information and provide that information to the court. Client absolutely post-dispo can choose not to reveal that. If they don't, however, this is when the court is going to say, I don't know enough because you're refusing to give me this information.
I think though, and I don't mean to argue, but I think that what I'm saying is if it's case specific, if it has to do with your case, I think you can absolutely put that on the form. You're not hiding anything. You've ordered me to do counseling or whatever. I'm going to talk to my therapist about this counseling, and that's what I'm giving you permission to see, if you want to do that.
Yes, limited.
You can limit
Rosetta,
it.
you have a question?
Yes, I have a question that's related to testimony and objections. Often in court, the judge will ask questions directly of the client, not during testimony, just during the course of a hearing. So for example, a couple days ago, I had a mother, UV case. She has a criminal protective order, but she doesn't have it with her. So the court orders the department to assist her in obtaining a copy, the court also directs questions directly to the client. When did you get it? Do you remember if the children are on it? And is asking my client questions, and I told my client to stop talking because I knew that she didn't want the CPO, and I was concerned that she was starting to talk and she would eventually say, I tried to get the CPO taken off, et cetera, et cetera. What is the proper procedure in that situation? Because we have that a lot where the court is questioning the client directly, whether it be about custody or ICWA or relatives, but they're just talking to my client.
Right. You wanna
I
take
think the
that?
court does have some leeway to do that, but you have to control it too. If it's, you see us going somewhere that you don't want it to go, you should make your objection to ask for the court, not to ask any further questions, requesting the court not to do that. But the court does have some leeway in asking, clients questions.
I think the court has leeway sometimes to, if it's vague about something and they want a little bit more, but I sometimes will interrupt and make my objections, and at some point in time, if it really goes on, say, it's the burden of the county council to put on their case and ask the
Now,
question.
that's true, but practically, I'm just telling you, the
sometimes
court's
they want
gonna
to
do it
clarify,
anyway.
yeah,
And so are you make your record?
right,
And so if you're gonna go up on that, you're probably gonna lose, unless it was really invasive.
because they do have broad discretion, I
They do,
think.
and they're gonna move, they have the right to move the calendar along too, okay, control the proceedings.
But listen very carefully to the question. If the question is objectionable, you should object to it, even if the judge is asking. I've made objections to the judge's own question and had the judge sustain the objection.
But she's not answering. But wait a minute, Yeah, she's
Well, no,
not.
the issue was that the judge wasn't asking questions that were objectionable, but I was concerned that my client was gonna give too much information.
Not understand,
When
right?
I do in that
Not
situation,
understand.
the client's sitting right next to you, it's not a trial, the judge is, so a lot of times the judge starts asking, and I'll just say, excuse me, Your Honor, I'm very nice, excuse me, Your Honor, just give me 1 second with
Yeah.
my client. And I'll turn to my client, I'll start asking them the same question, but I'm whispering, and then they're talking, and then all of a sudden, I start answering the judge.
So that's-
Your Honor, and then I take over. It sort of distracts the judge from talking to my client, and then I start answering the judge without the client having diarrhea of the mouth. Okay, so that's a tactic you can begin, is you get a theme from your, but again, what you're trying to do, just like with the objections with argumentative, you want to slow the process down, and you're doing the same thing. You want to stop the judge from questioning your client, and you want to redirect the judge to ask you the questions so that you can ask your client, and then you feed whatever you think would be appropriate back. But you're slowing things down and narrowing.
So my style was that it would be just what Marlene explained. I would answer the questions and then take it over if I knew. So then the judge's attention is to me, not to my client. I take the attention off of my client. Claire?
What if your client, you're just making a special appearance for this client and you can make requests, you can make objections? How do you handle that situation?
What do you mean by a special appearance?
You only specially appeared and the judge is directing questions and the
We're not in
client-
trial?
Pardon me?
I know,
Without a
that's the
trial,
Claire. Are we
like-
not in trial?
Without a trial, like sometimes I've seen the judge like ask questions about paternity to the parents and you're like, you can't make any objection, you can't speak on their behalf.
You can make an objection.
You can?
You can. I will, what would be?
I'm not sure I'm
By
following.
making an objection,
You're-
aren't you crossing the line into accepting the
To a
point
general
and
appearance?
citing all notice?
Marlene, this is your favorite subject matter.
I would say honestly in that situation, you need to put everything on the record. You'd have to again say, Your Honor, I'm in special appearance mode. That doesn't mean my client doesn't have an attorney, but I'm in special appearance. That means as an attorney representing someone in special appearance mode, we cannot answer these questions right now. If you have issues around paternity, we'd ask that the court wait until the next hearing, let's resolve the issue of special appearance. If it has to do with release, usually I've already talked to minors counsel. So if minors counsel is gonna say, we want the department to check out this person's home or check out the relatives, I'd say, Your Honor, talk to minors counsel. But you have to maintain your special appearance, especially if you have an Ainsley issue, you don't wanna waive that. So again, you're redirecting the court away from your client.
But I understand, you're making a special appearance, I lost that. So I would instruct my potential client before going in not to answer any questions, because you already know what the issues are gonna be before you're a bench officer. They may try to do this, or they may try to do that. So you instruct your client before you go in, you know, to not to answer something. Or you have a sign, if I put my hand like that, be quiet. Whatever it is that you instruct, so you don't have to go on the record. I missed that.
Just to add with Sherri's comment about special appearances, I usually try to get other people who are aligned with me to do the
Right.
work for me.
Right.
So whenever you have a special appearance, try to get, if minors counsel aligned with you, or another attorney is aligned with you, have them make the request for visitation. I have them do all sorts of things. So just ask them to make the request, make the objection.
And Alda, please, since it came up, special appearances are only if you have a potential Ainsley motion or a Hague notice issue.
And you should talk to your supervisors and your director about that,
I think you have another.
making special appearances.
Okay, I'm sorry.
We've been told not to make special appearances
Yes.
and only to appear as a friend of the court. Does anybody know why we're being told that?
Because technically, there's no such thing as special appearance.
No, that's not correct. There are special appearances that you do need to make for Hague and Ainsley issues. What we're no longer doing is those conditional appearances, because the appellate attorneys have told us there is no such thing as a conditional appearance, and that's a whole other training, guys.
It's a different
Yeah,
term.
okay, yeah, that's outside of trial schedule.
You're talking about incarcerated
I
lawyers,
was
so they
gonna
want you to
ask
talk.
about, when we were talking about conjoint counseling
Who, me?
earlier,
Oh, I was,
for raising the privilege that we think is waived when the parents and the kids are doing conjoint counseling together. If that counselor is also doing the kids' therapy, have they waived the privilege then? Because in essence, they're addressing case issues.
where, I'm sorry, where are we?
I was like 5 questions ago, but you did.
Carolina, I'll help you out. We were talking about privileges, and then you were talking about therapist privilege, and then Rachel said something, and then Marlene said that when you're in conjoint counseling, the privilege is waived because minors counsel is a holder of the for the child. So Carolina's question is, if that conjoint therapist is also the child's individual therapist, then what's the rest of your question?
If
Is
the
that your
privilege is
question?
waived for their individual counseling session.
Is that your question that she stated?
Perfect, yes.
Okay. You know the answer now, right?
I don't.
Marlene, what was the answer?
She didn't give the answer to that, that's
She
why I
did give
asked.
the answer to that. She did give the answer to
Because
that.
they're still having separate sessions, and even as minors counsel, even though you hold a privilege, how you exercise that privilege still varies. So the minors counsel may say, I am authorizing you to disclose information through conjoint counseling, but I am not authorizing you to disclose information through my client's individual counseling. So then it's gonna depend on whatever release minors counsel finds.
So you want to limit it, right?
Because they're addressing case issues.
You know, the good.
That's right,
good-
I think that's the best answer that Ms. Neal gave.
Yeah.
And the really good conjoint therapists, they won't do that because of that problem. The good therapist won't do the children and the children and the parents. The agency will assign one person for conjoint and one person for individual. Exactly for that reason.
Okay. You want to add anything?
Any other questions? Okay, thank you very much for coming in.
Thank you.